Well, the South was a region with segregation, with a caste system of race, in which blacks were excluded from the political process, and in which inferior social and political status was enforced both through formal law enforcement as well as through extrajudicial terror. And that was really the reality of American apartheid that the Supreme Court was confronting when it began dealing with issues of race in the 1950s and in the 1960s, and it was the court that really had to step into this racial policy void. So Brown v. Board of Education in 1954 was the decision that said separate is no longer equal and we're not going to tolerate this anymore. Of course, we're not going to tolerate it with all deliberate speed, and we're never quite going to get around to dealing with all of the problems. But the simple fact that the Supreme Court said separate but equal is no longer the law of the land provoked massive Southern resistance. And there was an enormous politics that mobilized around the illegitimacy of the Supreme Court, judicial activism, a recurring theme we will talk about during the Q&A. And Brown v. Board was the beginning of that process, and the Southern officialdom resistance to that, and the civil rights movement in turn mobilized in response to the Southern resistance to Brown v. Board. Anyhow, by the early 1960s, in 1964 we got the Civil Rights Act, in 1965 we got the Voting Rights Act, and it was basically the only time in American history in which the Congress, the executive branch, and the judicial branch all were in accord on issues of racial policy and imposed national legal equality norms on the recalcitrant South. And sort of everything important about understanding contemporary American politics and crime policy and welfare policy and drug policy and everything else happened in that narrow window between 1964 and 1968, which happened to be the time when I was in college and participated in my first civil rights demonstration, and in '68 was working for the Office of Economic Opportunity, waging the war on poverty. But I didn't know at that time that that was really the fulcrum on which everything that was going to happen in American public policy was playing itself out. I was just, some kid going to college and law school and, trying to burn the world down. During the same period, the Supreme Court also began the process of overseeing state criminal procedure, because the Supreme Court had another problem, which is that the Constitution didn't give the court much authority to regulate state criminal procedure. So for most of the 1920s and the 1930s and the 1940s, the Supreme Court would occasionally invoke the Due Process Clause of the 14th Amendment to say that some particular state criminal procedure was an inappropriate one. And mostly when the Supreme Court would decide the criminal procedure cases, they were cases that involved Southern justice and issues of race and issues of the death penalty, so that confessions extracted by torture in Brown v. Mississippi, or appointing counsel on the morning of trial in a death penalty case was Powell v. Alabama, the Scottsboro Boys case, so that the Supreme Court would occasionally deal with these issues, but on a very limited basis because of the constraints of federalism. It was only in the 1960s that the Supreme Court started aggressively deciding cases of constitutional criminal procedure. And it did it because this was really part of the civil rights agenda. And so the court in the 1960s gave us the due process revolution. And the due process revolution transformed criminal procedure, transformed juvenile justice procedure, and it reflected a number of strains running through it. Concerns about equality, concerns about limiting state power, concerns about controlling discretion by police and other law enforcement officials. But running through all of it was the issue of race and the relationship between the state justice systems and racial minorities. So the Supreme Court incorporated provisions of the Bill of Rights and applied them to the states. The Supreme Court reinterpreted all of these provisions of the Bill of Rights, and it infused the entire criminal justice system with a greater emphasis on equality as a way of building a real adversarial process into state criminal justice. The same processes are also going to play themselves out in the context of the juvenile justice system. So cases like Kent and cases like Galt are really just additional examples of this broader due process revolution going on in the juvenile justice system itself. Also, during the 1960s, there were other things happening. One was the beginning of the systematic critique of rehabilitation as the underlying ideology of both the juvenile justice system and the criminal justice system. So people on the left were critiquing the rehabilitative ideal and indeterminacy and treatment and probation and parole and all of those things as just coercive tools of social control by the state. Liberals were concerned about inequality of decision-making based on the discretion exercised by criminal justice personnel, and the conservatives were concerned about law and order and the need to repress criminals. So that the left and the right and the center all came together in the 60s and particularly in the 70s to describe an alternative ideology emphasizing consistency and uniformity and proportionality in justice administration. So that's sort of the intellectual backdrop playing out at the time the Supreme Court is making the decisions. In Kent, where the court observed that the child receives the worst of both worlds. He gets neither the protections accorded to adults nor the solicitous care and regenerative treatment postulated for children. And so the court was really, for the first time, taking on the procedures of the juvenile court. In Kent, dealing with questions of waiving kids to the criminal justice system, and subsequently in Galt, where the court really began the process of reconstructing the juvenile court and making it into a court. The court's impetus in Galt was to say there is this profound disjunction between the rhetoric of rehabilitation and the reality of what we're giving to kids. And there's a similar disjunction between the procedures available to adults and those that are available to juveniles. And so the Supreme Court said we're going to have to give kids some procedural safeguards. Not the procedural safeguards ultimately that adults are going to enjoy, but some modicum of procedural fairness. With one important exception, which is the Supreme Court also said juveniles are entitled to the privilege against self-incrimination. Now, it's a whole separate lecture about why the privilege against self-incrimination is the bulwark of the adversarial process. But it was the Fifth Amendment component of the Supreme Court's Galt decision that was, in a sense, the most important for changing the structure of the juvenile justice system. And it was going on at the same time, the Supreme Court was deciding Galt at the same time that the President's Commission on Crime was looking at criminal justice policies and juvenile justice policies and was doing what was the largest empirical study of justice administration that had taken place in the U.S. in about 3 decades. And the President's Crime Commission, returned a pretty substantial indictment against all of criminal justice administration and juvenile justice administration, and particularly was concerned in the juvenile court context that when we look at the large cities in which delinquents are being prosecuted, that there's a vast disproportionate overrepresentation of racial minorities, and none of these kids are getting lawyers. That they're just sort of getting run through what the court in Galt described as a kangaroo court. There were a couple of more decisions that the court threw down in Winship that said juveniles have to have proof beyond a reasonable doubt, just like adult criminal defendants, and in Breed v. Jones, where the court said that juveniles are entitled to the protections of the double jeopardy clause because a delinquency prosecution is the functional equivalent of a criminal prosecution. But importantly, the Supreme Court in McIver v. Pennsylvania denied juveniles the right to a jury trial. And this is another sort of critical distinction between juvenile justice administration and criminal justice administration. Because by denying juveniles the right to a jury trial, we undermine the quality of justice in juvenile courts, and we inhibit the delivery of counsel in juvenile courts, and we ultimately institutionalize a second-class justice system for children.